We're going to leave the roll open to allow other members to add on.
So he's got a second item with Assemblymember Dodd.
Correct. So if you would go ahead and present AB 2888 with Assemblymember Dodd.
Good morning, and thank you very much, members. This is Assembly Bill 2888 with Assemblymember Dodd. This bill would close the loophole in the current law that allows judges to impulsively sentence perpetrators of sexual assault to little or no jail time by adding certain types of sexual assault offenses to the existing list of offenses that have a mandatory denial of probation. In March 2015, a Stanford University student was convicted on 3 felony accounts of sexual assault of an intoxicated, unconscious woman. Despite the fact that the defendant was eligible for a sentence of up to 14 years in prison, the trial judge sentenced the defendant to 6 months in jail and 3 years probation. The sentence has been justifiably criticized by many as shockingly lenient, given the horrific nature of the crime. With me in support is Assemblymember Bill Dodd, as well as the Santa Clara County District Attorney Jeff Rosen and the Deputy District Attorney Alalay Kianursi. Respectfully ask for a vote.
Mr. Chair and Senators, thank you very much for the opportunity to be here today. I'm proud to join with my Assembly and Senate colleagues in authoring AB 2888. Assemblymember Lowe has thoroughly told you why this bill is needed. I don't intend to repeat his testimony. What I briefly want to emphasize, though, is that AB 2888 underscores the landmark policy established 2 years ago when the legislature enacted SB 967 by Senator De Leon. That legislation, the so-called Yes Means Yes bill, required our institutions of higher learning to adopt a policy concerning campus sexual violence, domestic violence, dating violence, and stalking. Clearly laid out in that legislation is the fact that a victim of sexual assault cannot be deemed to have consented to any kind of sexual activity if they were unconscious or incapacitated due to influence of drugs, alcohol, or medication. AB 2888 fixes a problem in our law pertaining to the sentencing of someone convicted of sexually assaulting an unconscious, intoxicated victim. We need to send a message that sexually assaulting vulnerable victims who are intoxicated or unconscious is a serious crime. Letting a rapist off with probation or little jail time re-victimizes the victim, dissuades other victims from coming forward, and sends the message that sexual assault of an incapacitated victim is no big deal. To not address this problem would be to undermine the protections we require our universities to adopt and implement just 2 short years ago, and would hurt our efforts to change the culture on our campuses. This bill is sending a message that we stand behind what we did with SB 967 and that this type of crime is unacceptable. In that way, this bill is about more than just about the sentence. It's about changing a culture and preventing future crimes. I join Assemblymember Lowe respectfully urging an aye vote. Thank you.
Witnesses in support.
Thank you. Good day, members of the committee. My name is Alalay Kianursi. I'm a Deputy District Attorney in Santa Clara County. I prosecuted Brock Turner for sexually assaulting Emily Doe while she lay unconscious behind a dumpster. I'm here today in support of AB 2888. I'm here today because the pain so powerfully spelled out in Emily Doe's letter, reflective of the pain of thousands of other women, is missing from our penal code in California. Our laws sadly ignore 2 truths that I can speak to with confidence because I was with Emily Doe soon after she was attacked. I was with her on the stand. I was with her when she read her letter in front of her attacker. And I was with her when she heard the judge read his rationale for the 6-month jail sentence that outraged the world. The first truth not adequately represented in our law is that victims can be severely traumatized even if they cannot recall being sexually assaulted. Is it somehow less traumatic to have a police officer or a prosecutor explain in detail what happened to a victim than it is if she knew it firsthand? Emily Doe wrote, I was not only told that I was assaulted, I was told that because I couldn't remember, I technically couldn't prove that it was unwanted. And that distorted me, damaged me, almost broke me. The second truth is that there is a prevailing perspective that sexual assaults should be stratified by seriousness depending upon the type of penetration. As a veteran sexual assault prosecutor, I can say that the trauma experienced by survivors cannot be measured by what exactly was put inside them without their consent. I'm asking you respectfully to consider this bill after reading the victim's letter one last time. It will only take you 10 minutes. It is a raw and honest portrait of why we need to reconcile the law with the tragic reality of campus sexual assaults. We all need to try to protect the next Emily Doe against the next Brock Turner. It's on us.
Other witnesses in support?
Yes, I'm Jeff Rosen, the District Attorney of Santa Clara County. I'm here to respectfully ask you to close a loophole in our law that allows Brock Turner and future campus rapists to serve a sentence of only a few months in county jail. As I speak today, California law mandates that a defendant's use of force during a sexual assault triggers a mandatory prison sentence. However, when a victim is unconscious or severely intoxicated, in which case a perpetrator does not have to use force, prison is not mandatory. The victim's increased vulnerability actually protects the perpetrator from a harsher penalty. This misguided distinction between assaults provides courts the misguided discretion to give probation to perpetrators of sexual assault against intoxicated and unconscious victims, which may include little or no jail time. So today, a perpetrator at a college party who forcibly rapes a conscious victim will go to prison. However, a different perpetrator at the same party who chooses to watch and wait for a victim to pass out before sexually assaulting her can get probation. The details of the attacks are distinctions without a difference. Ask Emily Doe. Ask the thousands of young women who've been victims of similar crimes on campuses all across our state and country. This bill takes away none of the protections any defendant has against false incrimination. Our system of checks and balances remains solidly in place. Prosecuting, quote, he said, she said cases with little or no corroborating evidence remains extremely difficult, even if you pass this law. I respectfully ask the committee to recognize that AB 2888 will help hold accountable sexual offenders who go unnoticed within our state's college campuses. Unnoticed because they don't fit some people's image of a predator. Instead of brandishing knives or threats, these predators use vodka or beer. They use the cover of an outdated, offensive perception that campus sexual assaults are simply youthful, drunken indiscretions. Violating an unconscious woman is never an indiscretion. It is a violent, predatory, and deeply destructive crime. It should be treated as such. A natural consequence of drinking too much is a hangover, not a sexual assault. Thank you.
Other witnesses in support?
Mr. Chair, members, Dan Filisato on behalf of the Los Angeles County District Attorney's Office. For the reasons stated, we are in support.
Sean Hoffman with the California District Attorneys Association, also in support.
Michelle Thomas Shaw, representing Alameda County District Attorney Nancy O'Malley, in support.
Jonathan Feldman with the California Police Chiefs Association in support.
Dawn Kepke on behalf of Crime Victims United of California, also in support.
Corey Salzillo, California State Sheriff's Association, in support.
Do we have witnesses in opposition? If you wouldn't mind making some room for them, that'd be good.
Hello. I wasn't planning on speaking about this bill because I didn't know that it was coming up, but I'm from Santa Clara County. I'm very familiar with the Stanford case, and I would like to say that a complete picture has not been painted here today. The victim herself said that she was interested in restorative justice, and had the perpetrator been come forward and said that he was responsible and taken responsibility for what happened, she was amenable to a lesser sentence. What we have done now across our state is made the consequences so high, and the sex offender registry a lifetime sentence, that judges think if they don't go to jail, they'll be on the sex offender registry for life, and that's enough. If we didn't do this, perpetrators would be in a better position to go ahead and take responsibility for what had happened and not drag people through the criminal justice system, including the family members and the victim. She did not want that. She was amenable to restorative justice. And I think that it's important that this committee understand that.
Ma'am, if you'd identify yourself.
Yes, my name is Pam George.
Thank you very much. Next witness.
Good morning, Madam Chairwoman, members. Micah Doctoroff on behalf of the ACLU of California, here in respectful opposition to the bill. For over 30 years, California has been increasing sentences and creating mandatory minimums in response to specific cases and court decisions. This type of hasty policymaking has had unintended consequences on our communities, consequences that our state is just now trying to remedy through sentencing reform and other criminal justice reform. As we have learned again and again, mandatory minimum sentencing is poor policy that disproportionately impacts communities of color. People of color are arrested and convicted at higher rates than white people. Studies are increasingly showing racial bias in the courtroom, with judges sentencing people of color more harshly than they do similarly situated white defendants. California law already provides an adequate sentencing scheme for the serious crimes addressed by this bill. We do not believe that quickly changing our sentencing laws yet again is the right answer to this serious problem. And for these reasons, we respectfully oppose 2888.
Are there other speakers in opposition to the bill?
Khalif Osagai on behalf of the California Public Defenders Association, also in opposition to this measure.
Again, Jean, and mother of incest survivor, I'm also in opposition.
Okay, Senator Monning. Oh, I was simply going to ask if the authors of the bill would like to respond to the opposition, which I believe the issues were the increasing felon. Excuse me, are you trying to testify?
No, she's with the
Oh, you're with, okay. The fact that I did read also the statement of the victim in the Stanford case, saying that she wanted restorative justice and was distressed. And the larger issue of increasing penalties.
First, Madam Chair, thank you very much for the opportunity to respond. I think clearly what we're trying to do is make, as we've all pointed out, a consistency with the type of crime, whether you're involved in a rape when somebody's conscious and fighting you off, or whether they're unconscious and totally vulnerable. So what we are seeking to do here is to bring that consistency to. I don't disagree with the comments from the opposition, but I think it's important that we send a message that we have consistent rules and regulations when it comes to sexual assault.
And Madam Chair, we just, with respect, simply put, rape is rape, and we believe that there should be consistency in addressing this issue. And with your indulgence, if the prosecutor would be interested in also addressing this issue.
Thank you. I am in contact constantly with the victim. That statement in the probation report does not accurately reflect her feelings about what it was like going through the process of testifying. She absolutely was in support after she read the statement, went through the process of the defendant being sentenced to prison of a mandatory minimum of 3 years. And I believe there's some more comments.
No, we're not going to have the whole thing all over again, sorry.
It's up to the chair.
36th bill. I saw you shaking your head, though.
Yes, I was going to say that because the penalties have been made so high, there's absolutely no reason for somebody who has been accused of this crime not to drag somebody through the process.
Okay,
and she didn't want to be dragged through the process, and neither did her family.
Okay, thank you. Senator Monning has a question.
Thank you, Madam Chair. In response to the opposition, I normally am in agreement that we keep bringing mandatory minimums, the erosion of judicial discretion. This case, however, as I hear the proponents, we're seeking to actually bring a level of equilibrium in a similar class of crime that through lack of consistency we don't have. I would like, with the chair's permission, to direct a question to District Attorney Rosen.
Yes.
I'd like to start by welcoming you. He's the DA in one of my counties, in Santa Clara, and appreciate your being here today. Under existing law, could you just explain again the sentencing judge in this case of the
Yes.
incident at Stanford? Could you just explain the limitations that judge faced in sentencing because of current law?
The current law allowed the judge in the Stanford case to find unusual circumstances and sentence the defendant to probation. And the unusual circumstances that the judge found are actually the same circumstances that will be found in almost every campus sexual assault. That is that the perpetrator is young, has little or no criminal history, has a demonstrated record of achievement, which is why they're in college, has a strong family support network. So that's why the judge was able to, in the Brock Turner case, as well as any other campus sexual assault case, find probation.
But the fact that the victim was unconscious at the time the crime was committed, did that limit the judge's sentencing options?
Yes, the fact that the victim was unconscious in that case allowed the judge to sentence the defendant to probation, whereas had the victim been conscious, the judge would not have been able to sentence the defendant to probation, and would have had to sentence the defendant to prison, minimum of 3 years, maximum of 8 years.
Thank you, and that answers my question and why I will be supportive of the bill today.
Okay, so
Prepared to make a motion.
is that a motion?
It is.
Madam
Thank you.
Motion from Senator Monning. Senator Anderson, Senator Stone.
Assembly members, if you end up taking another motion, another amendment, I'd like to be added as a co-author, please.
What's the other amendment?
I said if they decide to take an amendment down the road, they're off to appropriation, so I'm hoping, probably me, I'd co-author.
I'm sorry, I was in another committee.
No, he didn't offer it. You might want to ask.
Do you in fact have a technical amendment you want to offer?
Yeah, so we will be taking the technical amendment, which is the reference of Section 289D and 289E with respect, but we will not be taking the amendment that would grant probation to unusual cases. So we will, again, just clarification, be taking the technical amendment, and Senator Anderson, be delighted to add you as a co-author. Thank you very much.
Okay. Senator Stone.
Thank you, Madam Chairwoman. I, too, would like to be added as a co-author if it's amenable to you, too. But I'd like to ask the district attorney another question. My understanding is that if you're raped and you're unconscious, that you can be given probation, but it doesn't limit the judge's authority to give prison time. Is that correct?
You're correct. Under existing law, rape of an unconscious person, the perpetrator is eligible for probation, but the judge can also sentence that perpetrator to prison.
So this judge did have the opportunity to send this Brock Turner to prison if he found the punishment to be appropriate.
That's correct. This judge had the option of sending this perpetrator to prison, but chose to give him probation.
And I think that's what outraged the public. This was such a horrific crime that was illuminated so the public could see the deficiency in California laws. And there's no question, conscious or unconscious, the woman was raped and obviously very much traumatized and having to relive the experience through a court proceeding. But I think the public supports what the authors of this bill are trying to do and take away the judge's discretion. If somebody is unconscious and they are successfully raped, that they will go to prison and they will not be given the opportunity to have probation. And I want to applaud the authors for bringing that forward. I think that's what is appropriate. I agree with Senator Monning that it kind of creates parity for rape, conscious or unconscious. You're going to go to jail. You're going to go to prison. And thank you for bringing it forward. Happy to support the motion.
Senator Leno?
Madam Chair, thank you. For all my years on public safety and chairing public safety, I'd never dealt with this issue of law, and I was new to all of it. I had no idea that there was this probation ineligible list of crimes, and then there was this probation eligible. And so, though I am often shy to support changes to statute because of a particular incident, and we all respond to horrific crimes in our districts, and we feel a responsibility to do something. And oftentimes it has been to the detriment of the proportionality and consistency of our penal code. But that notwithstanding, I started from scratch on this. And I thought, what's the more despicable crime? The sexual assault or the sexual predatory assault? In the latter, the victim is the weakest, the most defensible, the most vulnerable. Isn't that the more serious crime? So I'm not suggesting that we flip it entirely and that we give greater punishment, but at least equal punishment. And to pick on the most indefensible. We've got an old saying you hear in the schoolyard, pick on someone your own size, as if that's a crime in itself if you don't. This is an example of someone who didn't even want to take the chance that someone put up a fight, just wanted to do what he wanted to do. So after having thought it through, I am very supportive of the bill today.
Okay, thank you. The bill has been moved. I think committee members made some very good points. I also was new to this issue and did read the entire probation report and do realize that things are always a little more complicated than the news story. And I guess my takeaway is I agree with the consistency in this case. What struck me is the enormous cultural problem that we have on our campuses of sex, rape, drinking, binge drinking, going out with the intention of hooking up and getting drunk. And where on earth are our campuses on this? Where is the culture of our dormitories and fraternities and sororities? And we've got a problem that's way bigger than law enforcement here. And this is a step that we can take today, but I really think there's a lot more and much deeper work than that we need to do to address this very real problem that so many of our young people face. But having said that, the bill has been moved by Senator Monning. Would you like to close?
Thank you very much, Senators. Certainly appreciate the comments that were made, and what you see here is a culmination of the opportunity for us to address a very important issue in finding parity and justice. And with that, I respectfully ask for your aye vote.
Thank you. Please read the roll.
Hancock?
Aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Glazer?
Aye.
Glazer, aye. Leno?
Aye.
Leno, aye. Liu? Monning?
Aye.
Monning, aye. Stone?
Aye.
Stone, aye.
That bill, I believe, has enough votes to pass. We'll hold the roll open for the absent members. Assemblymember Bonta. Is he here still? Yeah. Two items, 26 and 36. 26 is